Good evening. Welcome to Lawyers on the Line. I'm Jim Peterson, a partner at the Falsani Balmer, Peterson and Quinn law firm, and this evening's moderator. Tonight we're talking about workers' compensation. When an employee gets injured on the job, that employee has the right to a number of benefits under the law. Handling medical bills and wage loss, changing doctors, getting back to work, and simply navigating the system can all be very complicated. I'm pleased to welcome tonight's panel, Sean Quinn of the Falsani Balmer firm, Kathy Bray, who's an in-house counsel for SFM Insurance here in Duluth, and Stephanie Balmer, another partner in our firm. We're ready for your workers' compensation questions. This is an hour-long show, so send in your questions. We'll have lots of time. Call locally at 218-788-2844, or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. Now, for our first question.
Ooh, suspense.
I'll get them out here.
Drum roll.
General question for the rest of you. We've done this show every year. We've had the Lawyers on the Line. Last year was about a year ago. Any changes in the law since the last time we were together for this?
Yes, I would say one of the changes that I can see hitting our community is part of more of a, I say, global or countrywide change with narcotics and the opioid epidemic and associated problems. Our local medical community is really clamping down on the prescription and monitoring of injured workers taking narcotics and other people, non-injured, people who are injured in other circumstances or need them for other pain relief. So what happened last year is some laws were changed that make it a little more regimented in terms of under what circumstances you can take opioids. And that's been hard for injured workers because I think our medical community doesn't necessarily have as many resources as other communities in terms of fighting pain and symptoms. So that jumps out for me. It's been a real issue for my clients.
Let's talk about that particular topic, because that is a big one. Kathy, I know you've spoken about this at seminars.
Yes.
What are the new rules and how are they supposed to be implemented?
Well, it's interesting that the opioid, these treatment parameters, so as Stephanie mentioned, it is a little more regimented, but there's also some structure which really is to protect the injured worker as well as provide some predictability with managing care. Opioids aren't something great for most people to be on long term. And so there is a real interest in making sure people don't have more opioids than they need in order to manage their pain, because there can be side effects, as well as potentially creating more pain problems. At the same time as these opioid treatment parameters came into play, there was also an authorization for medical marijuana in the state of Minnesota. So that's also a huge change, also affecting chronic pain. The addition of intractable pain was added for medical marijuana, which implicates potentially a workers' compensation claim. And that's a whole probably show in and of itself in terms of pain management, the role of medical marijuana and how it interrelates with other issues. But I agree with Stephanie, it's a big issue facing our community that we're trying to get a handle on, as well as the nation as a whole.
Okay, well, Sean, opioids are mostly synthetic, narcotic-type pain relievers. These new treatment parameters are multiple pages long. Can you summarize kind of how they tried to go about regulating this?
As best as I can, and frankly, Stephanie and Kathy might know them better than I do, but what they did was what the insurers are doing is they're sending out letters not to the employees really, but to their doctors and saying, hey doc, you've got this patient of yours, he's a workers' comp patient. He's been on these narcotics for a long time. We've got to slowly roll him back. And for somebody who's been on narcotics for a few months or even a couple of years, it's difficult. There are other clients who have been on them for 20 or 30 years. It's almost impossible to deal with that kind of situation. It's bad for the insurer, it's bad for the patient too. No one should be on chronic narcotics that long. But what they're doing is they're telling the doctors, tell us why this person is on it, give us a plan for rolling them back. And a lot of the doctors are family docs because these people have been on them for a long time. They're not really used to dealing with chronic pain. They're ignoring the letters from the insurance companies. Then they send them another letter. Then they send a third letter. It's a real
these
problem.
rules, the rules are extremely
They're very
detailed.
complicated.
Right.
You know, I mean, they give, as I've understand them, they give each type of narcotic a specific rating in terms of a dosage compared to morphine,
Right.
and you have to
The
add
morphine
up,
equivalents.
morphine yeah, and you have to add up. You know, if you're taking 4 Lortabs and 3 oxycodones a day, you have to do this, you know, math almost.
Right.
And doctors don't like math.
No, they don't. Well, lawyers don't either.
No, lawyers even
But
more.
there is a reason behind it. I mean, I think unlike some other regulatory schemes where a lot of people may say, well, this is just ridiculous, it really is important to understand the combination of drugs they're getting in terms of those morphine equivalents. It's also important that there are some safety precautions there with making sure they've had a drug or urine screen. Are they actually taking what they're supposed to be taking, and is it showing up in the proper dosages? Because, and certainly I'm not suggesting this is the majority or even a significant group of people in the workers' compensation system, but there are people out there who are abusing the drugs. There are people out there selling the drugs. There are people out there mixing them with other illegal substances, which are all contraindicated to prescribing them, particularly under the work comp system.
Right. And then the other problem is, even if people are using them as prescribed, they're terribly dangerous after a certain amount of time. And there are people that just, they kill themselves, not on purpose, but they end up just dying in their sleep because of the effect of the long-term usage. And that's the reason behind these rules. So the rules are well intended, and most pain doctors will tell you, look, opioids are really short-term medicines. They're not long-term medicines, but it became a long-term medicine in this country for the past 20, 30 years, and that's the problem.
Well, and the two of the, you know, I don't think anybody's going to disagree with that point, but what I'm seeing, again, in our community is when doctors either decide it's time for you to go off your narcotics, there isn't necessarily something in place to deal with that person's pain. And so that's a black hole for me. That I have concerns about people, you know, seeking alternative remedies, regardless of the legality. And then the other issue is, as you said, you know, we have all this paperwork. And if we have medical providers who are responsible for doing this paperwork, it's a bureaucratic mess. So what happens is the doctor doesn't, you know, want to do the paperwork or feel like doing the paperwork, or it's too much. And so then the meds get denied. And right now we're having a lot of private health insurance problems. And so you have these people who are at the pharmacy being told, you know, you have to pay $200 to get this med or else you're going to go through withdrawal. It's a mess, and there's really no system to fix it at this point. So
well, it's been the practice, at least in the Duluth area, for quite a while, that somebody on a long-term opioid regime is going to be put under a contract in which they have to submit to monitoring with urine screens to make sure that, number one, they're taking the drugs and not selling them, and number two, they're not taking other things, right? That's what you're talking
but then the
about.
question is, are the providers complying with it? Because what you have from the insurance company's perspective a lot of time is the fact that you don't get actually copies of the drug tests, you don't get proof of the compliance with the contracts, and then you get stonewalled by a provider or a doctor who feels like the insurance company is managing how they're managing the patient. But then that just creates more problem, because then the insurance company is not seeing the documentation to suggest this is appropriate. And at some point they say, I'm not going to pay for something that I can't even see that you're actually monitoring and administering appropriately.
Yeah, and the doctor's going to say, I don't want to deal with long-term opioid people, especially in the workers' comp system.
Right.
And then we don't have a treating provider for somebody who
Is
presumably
suffering.
needs the care, right?
Right. And then you have the opposite doctor who is very sympathetic, who will just keep slowly but surely ramping up the amount of narcotics that they're prescribing. So even though it's under a contract, you know, they were taking 1 Oxycontin a day. Now it's 2, now it's 3, now it's 4. And then the addiction becomes even worse.
Well, and keeping within the contract from the patient's standpoint, you know, I see a lot of people have no problem with it, but I've also seen a couple of glitches, and the problem with these contracts is they are so black and white. One major local health system, you know, one of the rules is you can't ask for your medication from anybody other than the prescribing doctor. What if that prescribing doctor's on maternity leave? What if you need to go out of town and you need to bank up on there's all sorts of contingencies, and I've seen it happen where an otherwise completely compliant patient calls and asks a question, and all of a sudden you broke your contract, you are done. Don't even ask.
And the patient feels like a criminal when they go to the pharmacy.
Yeah, you get accused of being drug seeking.
Right.
Before we leave this topic then, let's get back to the medical cannabis, because my understanding is the problem with opioids, among the problems, is that they attach to receptors in the brainstem, and so sometimes people who are just taking a normal dose, they're as prescribed, they're not doing anything wrong, they'll just stop breathing and die, right? And cannabis does not attach to receptors in the brainstem, so I've heard doctors say that it is literally impossible to overdose and die on cannabis. You can't smoke or eat too much or whatever.
Yeah, I think never say never is always sort of the way to go with that. I mean, not being a medical provider.
That's what I've heard.
Right.
Fake news.
Yeah, I think as a whole, it's probably a lot of doctors would say, and certainly at some of the seminars I've attended, most seem to be of the mind that as a whole, it's probably a safer alternative in many respects, but there's certainly some concerns with medical cannabis, and the problem is because it's been illegal at the federal level for so long, we don't have a good base of research to really help show us what's its efficacy, what's its dosage, what are the side effects. They're just sort of starting to try and collect this as it becomes more mainstream in some states. So the problem is with someone who has a history of mental health concerns, medical cannabis can potentially increase the risk of schizophrenia or some of those reactions. There are some other side effects. So it's got both sides.
Kathy, you represent an insurance company.
Correct.
And have you seen your company or others approve a cannabis prescription as a way to get out of the opioids?
We've had very few come in at this point. I can say that we have considered it on one or two claims at this point, and I think it's in the next couple years as a whole, we'll start to see, is this a reliable or realistic alternative for pain management or not? I don't think there's enough out there right now to show any kind of pattern or... Well,
and then there's one other problem, and you kind of alluded to it. I've got two pending claims right now where I'm trying to get medical cannabis approved for a client, and the defense attorney, and neither of them are with your company, has basically said, you're probably right, this is the better choice, but my company, my insurance company, is a company, multinational company. We're not going to violate federal law and start paying for this. Even though it's approved under Minnesota state law, we can't violate federal law. We just can't. If a judge orders us to do this, we're going to appeal it to the Supreme Court, the state Supreme Court, and eventually it might have to go to the U.S. Supreme Court. Will they take it? Who knows? But, eventually some federal judge is going to have to rule on this. Well, it's really complicated.
And basically, because it is an illegal substance at the federal level, most companies in different states who have administered this or authorized it as a treatment protocol will reimburse the employee. The employee pays for it and they reimburse it, and that avoids some of the federal banking transaction issues. But it is a very convoluted mess.
Yeah. And then for people in the Duluth area, it's especially complicated because we don't have a facility here in Duluth. The closest one is in Hibbing.
I think we now have one kind of storefront dispensary. There's someone out of the cities who will...
Storefront dispensary. I remember those. Yeah.
I don't think that's the name on the business card, but it's something along those lines. And it's coming. I mean, it's just a matter of when.
I mean, you open the paper and there's problems with medical marijuana in some of the companies and profit margins and everything else too. So it's got its own issues and its own little problems.
Here's a related question that came in from a listener, viewer. Person's hurt at work, had drug testing, probably in an industry where they do that, and the drug testing showed the presence of marijuana or cannabis, but has a medical prescription for it. What happens with the workers' comp claim, Stephanie?
Well, the first level of analysis would be did the consumption of the medical cannabis play a role in the injury in any way? I mean, if this injury would have happened regardless of the substance, you still have to prove that it was a factor. And then even then, if it was, in my opinion, if it was a medical prescription, it depends on what the job was and what the activities were, if it was prohibited or not to be using the substance. I don't know, there would be a lot of moving pieces on that, I think.
Well,
It comes down to whether they were impaired, and was
Right.
it at the time of the injury, or was it after the injury
And even
that
more
it
so,
came up? Because there is an anti-discrimination provision in the medical cannabis statute that indicates an employer can't retaliate just because of a positive reading, but also they can have rules saying you can't be impaired at work, you can't be impaired in certain kinds, or using in certain kinds of safety-related positions, as Stephanie alluded to. So it would really be a fact-specific answer on
right,
that.
and you would have to show not just that there was something in your blood system, but that it actually impaired you.
Well, and
And you don't have to prove that you weren't impaired. The employer, in the work comp setting at least, has to prove that this impairment played a substantial factor in the reason you became injured.
yeah, there's a statute on alcohol intoxication.
Same thing.
And it's something that exists but maybe never really
Right.
works. But how do you tell whether someone's intoxicated based on cannabis? I mean, there's no.
That was going to be my question.
Yeah. Sean, question from a caller. Why can't you get pain and suffering damages in a workers' comp case?
The short answer is because the law says you can't. I mean, that's as simple as that. The long answer is workers' comp is a compromise. It dates back to the Industrial Revolution, and there were a lot of people getting hurt in various factories and all this new technology that was existing back at that time. Rather than having employees sue their employer and the employer then blaming the employee for the injury or blaming somebody else for the injury, if you get hurt at work, you get benefits. But we're going to limit the kind of benefits you get. You get wage loss, you get medical, you get some vocational rehabilitation. Those are the three big ones. There's in Minnesota we have something called permanent partial disability, but you do not get pain and suffering. Your spouse doesn't get any money for their losses because of your injury, or your family. You get these very limited benefits, but then you don't have to prove fault. You don't have to prove that it wasn't your fault or it was a coworker's fault. You just get the benefits. It's a compromise.
Except in a railroad case, which is a little bit beyond our topic.
And that's not workers' comp. Yeah.
Stephanie, you're a curler.
Of sorts.
Here's a question from someone in Duluth. Curling at a work outing, fell and broke wrist. You broke your wrist curling. Even.
I did break my wrist curling. Yeah.
I already said
No,
it.
that's fine. I'd like to hear.
No, I already
Sean's
said it goes to
answer on
Stephanie.
that.
Yeah, I didn't call that one in, I promise.
The employees were encouraged to attend, but not required to attend. Is this covered?
I'm going to go with fact specific again. When you say that the employees were encouraged to attend, was it a company-wide party? Was everybody going?
I think there was a recent case on this. If only.
Were they paid? I mean, there's
Yes.
different factors that go
They were
into it.
paid to go to the party?
Well,
that's the
I
question.
believe what the case said
Yeah.
was that if it's unpaid and you can go if you want to or not, then it would not be compensated.
Right.
But if there's something else going on, and in the recent Supreme Court case, what happened was they were told, well, you can go or not, and it's not paid. But if you don't go, then you got to go to work.
If there's a punishment basically
Yeah.
attached to attendance or
Right.
not, then it's viewed as
Which made it not
implied you need to
Yeah.
attend.
Not quite as voluntary as intended. So
But if it had been like a Saturday outing where you just had your department say, let's have a fun day at the rink, then that's totally voluntary and that wouldn't be compensated.
right.
Yeah, any recreational activities are generally not covered absent you being forced to or making it mandatory. I mean, that's a general rule.
Kathy, I have two related questions here that I'm just going to throw at you. so we can get a little bit more edgy.
Okay.
Number one,
Boy.
why are adverse medical exams
Independent medical exam is the term we
in,
use.
why do you have to go to Edina for them? And why are the doctors allowed to lie?
Oh, wow.
I'm just reading.
I'm
it.
thinking. I'm thinking Jim Peterson wrote that question. Well, they're referred to as independent medical exams or quote adverse medical exams because they are scheduled by the employer and insurer. And under our statutory scheme, the employer and insurer have the right to request a medical examination when there's a dispute concerning medical care, treatment, scope, and extent of disability, things of that nature. Some of the exams do take place in the Twin Cities because there is a relatively limited group of doctors who travel to northern Minnesota. And so especially if you're looking for a particular specialty, it can be often hard to find anyone unless you have someone travel to the Twin Cities to be examined for that purpose.
You
And
didn't
then
answer the lying question part.
Then you would, I'm not done with my first answer though, but then the employee would be entitled to reimbursement of mileage or the related travel expenses if they were required to travel for the sake of that exam at the employer and insurer's request.
Sure, and giving you the benefit of the doubt, you and your company,
Yes.
and other companies, there's a difference between a doctor's opinion and a
Yes.
statement of fact, and
Right.
I guess there's some room for argument there. That's what we all do.
Exactly. I was just going to say, I think you'll find a lot of times the opinions on exam are different. Do they find limitation on motion or not? Do they find subjective complaints of pain matching the objective findings? So I do take issue with lies, but we see it on all sides, I guess, huh?
I don't know about
Zing.
that. Sean, question for you.
Why is Kathy allowed to lie about that answer about the doctor lying?
Sean, question from a viewer in Chisholm. I'll just read it here.
Sure.
Why is the insurance company allowed to pay my weekly benefits late? I'm sure they get their checks on time.
Well, whether the insurance company receives their premiums on time is irrelevant, but by law, the insurer must make the weekly checks payable within 14 days of proof of the loss. That means they have to put the check in the mail within the 14th day. If they don't, there are penalties for that, and they can be, depending upon the circumstances, because there's some discretion amongst the judge in awarding penalties. They can be very severe. I mean, it could be as much as 30% penalty, I think, is the high end. And so, but if the check, here's the, if the employee is off work and is getting paid, every 2 weeks, like a lot of people do on their regular pay, then the insurer is supposed to pay the employee every 2 weeks in these wage loss benefits. If it's weekly, it's weekly, same kind of thing. If the employee's working but making less money and getting that wage differential check, the temporary partial check, then as soon as the insurer has proof of that wage that they receive so they can do the calculation, 14 days. So they're not allowed to be late. If they are late, then they can be penalized. Sometimes the Department of Labor and Industry recognizes the penalty themselves and just issues an order to penalize. Sometimes the employee has to hire a lawyer and make a complaint.
Well, and on that point, if your adjuster or whomever's paying is showing a pattern of late payments, document it, keep track of it.
Right.
It's not going to be enough to say, I called you that one day.
Yeah. Save the envelope, and they'll have the postmark.
Save
Yeah,
the
that's
envelope, and I tell everybody in various areas of the law, phone calls are great when you're trying to get something resolved, but if you're trying to establish communications or prove that someone got something, fax or email, save everything.
Yeah, I think most judges will. If there's a pattern, if it happens over and over and over again.
Then it becomes more likely to be a penalty and a higher one.
Stephanie, here's a question. I was injured at work. My employer said he would pay the medical bills directly if I don't report it. What should I do?
Report it. Here's the problem is if you don't report it, and there are some shifting timelines depending on the type of injury and whatnot, but if you don't report it within the requisite amount of time, you could lose out. There may be a penalty for the employer's malfeasance, but Obviously, some employers don't want the track record. We've all driven by the work sites that say, we've gone 8 years without an injury. And this isn't good. This isn't a good practice because it dissuades people from reporting injuries. Even if you think that you're just going to need, one ER visit and the doctor pays for it and everything's fine, what if it gets infected? What if it gets worse? What if you go on to the next job and you re-injure that body part and that employer insurer says, well, this is from the old one? I mean, it's really better to report it, and employers shouldn't be doing anything to dissuade employees from reporting the injury.
But in that scenario, what you described, the boss said, don't report it. If the boss knows you did report it.
Yeah, that's a good point.
I mean, the only obligation the employee has is to report it to their boss. They don't have to report it to the workers' comp insurer.
Except that boss would probably deny it. I mean, if that's
so you might have to document the reporting.
Yeah.
But your obligation is to tell the boss.
An employer has the option of paying a claim rather than submitting it to the insurer.
Yes, they do.
But it still would be treated as a work injury just in case something happens down the road, I think.
I was going to say there's really limited circumstances where that would be advised, because it's still supposed to be reported as part of your payroll, still part of your experience. And also, I know SFM, the company I work with, strongly encourages employers to promptly help their employees report injuries, because the insurance company can also help manage the harm that could potentially follow from that injury by delaying proper treatment, by delaying proper attention to it. And there's ways to minimize the exposure and harm by properly having it get into the system earlier rather than later.
Yeah, we want safe workplaces.
Correct.
Sure. Kathy, I'm going to go back to you with this one, because I think at one point earlier in our talk you used the word impaired. And there's a question from a man in Hibbing who said, what's your definition of impairment as it applies either to workers' compensation or employment law?
In terms of, are we talking, I guess, drunk driving? When you hear impairment, I'm not sure what the caller is getting at. In workers' comp, if an individual is impaired when the injury occurs and it's the proximate cause of the injury itself, they may be barred from compensation. However, it's a very high bar, because if someone is, for example, up on the roof, they're roofing, they happen to have had a couple drinks before they got up there, they fall off the roof because, let's say, their harness gives way, then there's not necessarily a connection between the drinking and the harness giving way. That's the cause of the accident. So some may think, well, he was drinking, he shouldn't get benefits. So that's the kind of analysis you do there. In terms of employment law, there's certainly drug and alcohol policies on most employment places. So you may have a compensable work injury, but then be fired or disciplined because you were drinking while on the job. So that's a different analysis. And they may result in punishment on one side that is not punishing the work injury, but you're punishing the fact that you violated work safety rules.
If somebody has a work injury and is limited in their abilities to return to work, can the employer terminate them, Sean?
Well, the employer cannot terminate an employee because they had a work comp claim in and of itself. But if the employee can't do his or her job, then they can't do their job. And the employer is not obligated to provide light duty work. It's not required under the law. It might be required under a specific employment contract if the employee has one. If it's a union situation, there might be some union rules that mandate that. But absent some mandatory requirement, an employer is not obligated to make special accommodations, at least under the work comp law. Now, there might be some ADA rules that require special accommodations, and those ADA applies to only certain employers with a certain number of employees. So there's a lot of overlap of different areas of the law. But insofar as workers' comp, if you can't do your job, the employer's not obligated to save the job in and of itself.
Isn't there a Minnesota Supreme Court case that actually says that an employer is not liable for discrimination if it's a workers' compensation condition that leads to the discrimination? In other words, the disability discrimination laws specifically don't apply if it's a work injury.
Right.
So you're not even liable for doing that, much less have an obligation.
Right. But if you say, oh, you got hurt on the job, you're fired, That's not okay.
No, that's-
That's prohibited.
There's a statute that so Sean's right. An employer's not supposed to do that, but if they do, then you probably have a cause of action against them,
Right.
depending on the circumstance.
And that's hard to prove.
I was,
but
Right.
I was going to say I would caution taking it as a black and white rule that just because they had a work injury and you don't have work, you can safely terminate them.
Right.
Between the Family Medical Leave Act with employers over 50 employees, between the Americans with Disabilities Act, the Minnesota Human Rights Act, there are a lot of potential areas that intersect with even perceiving someone as disabled who's not anymore, fearing that they'll be re-injured and terminating someone just on that basis alone. So I always encourage employers to tread very carefully and consult with your employment counsel or your work comp counsel before taking adverse action against someone who is receiving work comp benefits in particular.
Right. And of course, the employer is opening up the workers' comp insurer to additional liability by terminating an employee. So it's not necessarily the smart move, but
Well, and if it's a retaliation type of situation where they're found to have retaliated, the employer actually has an uninsured liability under the work comp statute. It's called an 8-2 action, where they could be liable up to a certain amount that the work comp carrier wouldn't cover, in addition to potential civil actions too.
well, there's and that includes there are punitive damages, there are attorney fees under that law, and the employer's paying all of those out of their own pocket.
And the other part of that statute, in addition to the retaliatory provision, is if you can prove that the employer had work for you, but didn't give it to you, even though you were fit to do some of it. So,
Yeah. And that only applies to employers with 15 employees, I believe.
right. So this 8-2 statute, 176.82, provides some of these additional protections, I'd say.
Right.
Well, Stephanie, let's turn that around the other way. What if there's a worker injured, under restrictions, can't do the regular job, and the employer says, fine, come on in, I'll have you shuffle papers in the office, and the employee says, well, wait a minute, I'm a welder. What happens there?
Well, the welder should try to shuffle papers. Generally, if you're injured and you can't do the job that you were doing at the time of your injury, I tell all of my clients, if you can cooperate with working as much as you can, as long as it's within your restrictions, do it. It is good for everybody. It limits the employee's time off work completely. It provides income to the employee. It keeps the employee in the workforce. It maintains the relationship between the employee and the employer. As long as that relationship is working out okay, the work comp insurer doesn't have to pay as much. So it can be frustrating because people are frequently asked to do things outside of their comfort zone. But again, I tell everybody to try it. And additionally, Sean had mentioned one of the benefits that were available to injured workers as vocational rehabilitation, and that would be a great situation for a QRC, which is someone, I usually call them kind of Wonder Women. They have some men, it's a couple of men. And they have a lot of background in vocational expertise and frequently nursing. And what their job can be is to run interference, frankly, between the injured worker and the employer and the insurer, and sometimes the lawyers if they're involved. And so that would be a situation where the welder would say, QRC, I'm really having trouble doing this, or whatever the situation may be. And then the QRC would come in and say, well, let me try to help you, or let's try to accommodate that, or something.
What if it's humiliating?
Unfortunately, for workers' comp purposes, it's going to be hard to make that a factor. Injured workers are asked and sometimes forced to do all sorts of things to maintain their eligibility for their benefits. You know, we have clients who are unwilling or unable to jump through the hoops, and sometimes they are hoops, and those are really difficult conversations, and I absolutely agree with them. More often than not, you shouldn't have to do this. But as Kathy's mentioned, you know, some of this is making sure that people are not taking advantage of the system and that the benefits are being delivered to the people who deserve them. So,
Well, and frankly, offering employment to someone who's able to work and offering employment within restrictions shouldn't be viewed as a humiliating situation. I mean, if the employer can't get them back to welding, but they have work available in the office that helps provide some wage even, and the work comp then would make up the difference in the wages, that's something that the employee should be willing to do because they're capable of working. So the whole idea of work comp is getting people back to work. It's not the idea of keeping them off work if they're able to get back.
Sean, I have a question from a viewer, and I'm going to lob it to you as our Social Security expert. If you're disabled and on Social Security, can you still go out and work? And what happens if you do and then you get hurt again?
Huh. That's a multi-layered question.
Let's
So
hear
it
it,
wasn't
expert.
a lob.
We only have an hour, Sean.
Yeah, right. So the first injury presumably is a work injury. They're off work. They're collecting Social Security disability. Now they want to go back to work. Social Security law allows you to try to return to work. There's something called a trial work period, which can last 9 months. It doesn't have to be 9 consecutive months. And during those 9 months, you can make as much money as you want. The idea is to try to let the person get back to work and off of Social Security. After those 9 months, then if you're making more than a very rigid dollar amount per month, which is presently about $850 a month gross, then you don't get your Social Security for that given month. And this is for the next 36 months, an extended period of eligibility. If you're over that amount in the month, you don't get your Social Security check. If you're under, you do. All right, so that's the simple part of the question. The more complicated part, what if you get hurt at your new job? Well, you have another work comp claim. Of course, that work comp insurer is going to focus on the first injury, and then you might have 2 different employers and 2 different insurers involved in litigation. But it will be a long process of hashing that out. And if you haven't gone off of Social Security, then you still at least have that income. And if you have gone off of Social Security because you worked too much or made too much money, then you've got to start your Social Security application all over again too. So it can be quite a mess. But yeah, you can still have a second work comp claim.
I have 2 questions here that go back to our opioid conversation, and they both are the same type of scenario. A person is on long-term opioids. The insurer, either through the doctor or not, discontinues them. Person goes into withdrawal. Now they got other problems, maybe a hospitalization, maybe significant other treatment related to the withdrawal. Who pays for that, and is there a penalty situation for that, Stephanie?
I would say the work comp insurer pays for that as long as they were also paying for the opioids. And frankly, I've had claims where that's been the case. I had a case where a judge ordered the insurer to pay for the ER visits involving the withdrawal symptoms. So,
and I would say it depends.
It always depends.
Because if those opioids weren't appropriate, and the insurer said they shouldn't have been paying for it, and that's why they discontinued them because the treating doctor wouldn't cooperate with weaning and wouldn't cooperate with parameters, then I think there's argument to be said that the reason for the withdrawal is not the insurance company or the work comp injury's fault, but instead is due to sort of the medical mismanagement side of things. So I think it really, there's potentially 2 perspectives.
And that was the defense in our case.
But if a doctor commits malpractice on you while he's treating you, work comp insurer still has to pay for that and all the consequences of that.
If it's found related to the work comp injury.
And if the opioids are to treat pain, which is related to the injury.
I think there's a real question if it gets to the point where the work comp insurance company has said, we are requesting this information through the treatment parameters, or else we have information that suggests opioids are inappropriate to be used to treat this pain. There was a potentially even lead time given to try and get the person off of that, and they're still not cooperating, or the medical provider is not cooperating, and the insurance company stops paying for it. And then what happens after that point may or may not be a liability of the insurance company. So I think it really does depend on the circumstances.
Well, there are drugs that cause a dependency.
Correct.
Well, and at a basic level of analysis, independent of the opioid issue, to get medical care paid for by the insurer, you have to prove that it's reasonable, necessary, and causally related to the original injury. What we're talking about here are some of the spin-offs of what is and is not related to the original injury, and We're nerds, so we could talk about that all night long, but it's going to depend. Yeah.
You hear that, Jim?
I'm not.
You're a nerd.
No. Sean, we had two different questions about notice. Why is there a requirement for notice, which I assume means telling the employer about an injury?
Right.
And what are the timelines?
Well, the why is because the legislature put it there. I mean, that's there's a statute that says an employee must give notice. The statute says the employee must give notice within a reasonable amount of time. And if the employee doesn't give notice within, I think the first level is 14 days, then then there's no benefits unless if you can show that the employer-insurer has been prejudiced by that failure to give notice. The employer-insurer can never show prejudice, so that is a kind of a made-up rule. That's,
Wow.
I mean, I've never seen anyone not get benefits because of a 14-day rule. Now, then there's a 30-day rule, which is the general rule that most people like to follow. If you don't give notice within 30 days, you could lose all of your benefits. There are exceptions to that. There have been some cases over the past 5 to 10 years where the courts have really drawn a hard line on 30 days. There was a case a few years ago where a woman reported it on the 33rd day. She lost just because of that. Then there's the far-reaching end of the statute, which is 180 days. And if you don't give notice within 180 days, which is 6 months, you just don't get benefits. There is still one more exception, which is incapacity. If you're in a coma or something like that, then the time doesn't tick. I know, that's your dream.
Okay. Stephanie, I'll throw this at you. Person hurt on the job, out on workers' comp, gets released back to work, finds out that while off work, the manager has been belittling the off-work employee, complaining about how much money this has cost the employee or the company, and generally bad-mouthing the employee, the injured worker, to the other employees in the shop. Any recourse?
Not at the outset. It's poor management, certainly, and this goes back to the what we've been talking about. It benefits everybody to get these injuries reported and managed promptly. The only thing I can see down the road is that if this initial belittling and talking down turns into some sort of adverse consequence to the employee, you can't come back to work, or we're only going to give you part-time work, or we're going to stop giving you these jobs, or what have you, then some of these other statutes and safety nets that we've talked about could come into play as far as protecting the employee, but not under the work comp law.
Can you sue them for slander?
Oh gosh, that's another show.
Well, and I think Stephanie hit on an important part with the Workers' Compensation Act is not an employment law act. It's not an employment security act. It's not an employment protection act. It is a compensation system to address benefits for work injuries. And so when you start getting into terms and conditions of employment, that really implicates employment law and a whole other, or potentially labor law if there's a union contract involved. So the Work Comp Act is relatively narrow in that regard, and you have to go to a different scheme to look at some of the other issues.
Now, we also talked about those claims under 176.82. You can't fire somebody for bringing a workers' comp claim, for example. Well, this is a scenario where they're not being fired, they're just being humiliated. Well, the statute says you can't fire somebody for having a work comp claim, you cannot threaten to fire somebody for having a work comp claim, and you cannot impair their ability to receive workers' comp benefits. Theoretically, the humiliation or these comments could impair that. If that happens, then those claims could potentially exist too.
It's also really good evidence if there is some sort of termination down the road that was why.
Right, absolutely. Yeah. So it's a really bad move by the employer to do that.
Kathy, here's a question that got called in. Working as a roofer, slipped in the homeowner's yard, injured presumably. Who's responsible?
I'm assuming it's a roofer working for a larger company, so is acting as an employee. If they slipped in the homeowner's yard while working on the roofing job, they're in the course of their employment of that job. If they were on the clock at the time it happened, it should be work-related injury. There's a whole other issue of whether there was an actual hazard that caused him to slip. There was a case in the relatively recent past that said if there's not an increased risk of employment, then there is no compensable injury.
Increased risk of harm.
Increased risk of employment, sorry. Increased risk of harm from employment.
Yeah.
There's no compensable claim potentially. So if someone's just walking across the floor and there's no hazard and you just, quote, trip over your own feet, that might not be compensable even though you break your arm as you fall. So it depends for that roofer if there was something that caused them to fall in the homeowner's yard or if they just don't know what happened and they sort of went down and hurt themselves.
Yeah. And if they're just some guy that's doing the roofing, then, you know, hopefully they bought their own work comp insurance for themselves, because you can't sue, the homeowner's not your employer.
Sure, but if you slip and fall in a hole.
Now, if it's a hole, you might have a comp claim and a claim against the homeowner if that was a dangerous condition and the homeowner didn't do anything to warn anybody about it or repair it or protect around it, then the employee could have two claims.
And that additional claim, third-party claims, when you get hurt on the job as a result of a third party's negligence outside of the employment relationship, you can seek to recover some of the benefits that are not otherwise recoverable.
Like
in
the
work
pain
comp.
and suffering.
Or, you know, in work comp you get, well, yes. So
Yeah.
it's a whole other question.
Sean, I'll give you this one. When is the right time to get a lawyer? I assume in the context of our discussion here.
Right, right. As opposed to
I mean, generally,
when the
you should
cop
always
pulls
get a lawyer.
when the cop pulls you over and knocks on your window and says, "Roll it down." If you get hurt on the job, you don't necessarily need a lawyer. However, there is never wrong to call and ask questions. Under the work comp statute, attorneys representing injured workers only get paid under certain circumstances. We get paid a contingency fee. We have to work and help you get those benefits that are otherwise being denied, and then we get paid a percentage of those. That's a short version. So there's no harm in calling and asking questions. I have a few clients that the work comp insurer is paying everything. I'm not doing anything, but I'm there just in case something bad happens. If you're comfortable and everything's going fine, you don't want to call a lawyer, you don't have any questions, that's okay too. And then you get the letter. Hey, we're sending you down to the not lying doctor in Edina for an exam. That might be a good time to get a lawyer. You get a piece of paper in the mail saying we're going to cut off your benefits. That might be a good time.
Yeah, and until that time, though, you know, you're the lawyer, you've got a file open, nothing's being disputed. How much are you getting paid?
Zero. And I'm also not doing anything either, so I'm getting paid exactly what I deserve to get paid.
You know, Kathy's company actually does, I've seen a couple of files. You know, there are people who handle their claims to conclusion without hiring a lawyer, and her company will offer the employee an additional sum of money to go talk to a lawyer, just a one-time consultation, run everything by them. I've done that for SFM a couple times, just to make sure you're not signing your life away. So it is possible.
Yeah.
Stephanie, why can't an injured worker bypass the workers' comp system and just sue the employer?
Because it's against the law.
That wasn't a very detailed answer.
I think
No,
you did.
no,
Actually,
we
you touched on the whole trade-off
Yeah, I mean,
issue with your
Yeah.
Social Security. Not, yes.
Yeah, I know what you're talking
And you actually, because the system is no fault and because it's there and you're not meant to tinker with it, it's meant to protect the employment relationship too. Right. You're not suing the employer. Anybody who goes around complaining about their increased costs, that's a problem you have with the insurance company, not the employee who got hurt on the job. So it's meant to maintain that relationship too. It's a good thing.
Right.
Yeah, it's almost always, workers' comp is almost always the exclusive remedy for a work injury, except in some very rare situations that almost never happen. Right.
Right.
Yeah. Kathy, another question about going to a medical exam. Can you make someone go to a medical exam in the cities when you're in a wheelchair and don't have anyone to drive or accommodate that?
well, there have been situations where there's a certain specialty and you need someone to examine like some of the unique neurological injuries or neurological conditions. You need someone who's only based in the cities. If someone is unable to drive themselves, there are different kinds of medical transportation. There's some third-party transportation services that insurance companies can avail themselves to help get that person there. So if you're unable to get there, you need to let the person who scheduled the exam, the insurer, know, or if you have an attorney, let the attorney know so that they can let the insurance company know. And some alternative arrangements will be made. You can't avoid having an independent medical examination simply because you can't drive yourself. So it's something that under the statute, the employer and insurer are obligated or have the entitlement to have in the right circumstances.
Yeah, as long as they figure out a way to do it safely. And
correct.
Sure. Sean, there's a question. I am becoming depressed due to the work injury and inability to get back to work. Is this related to the work injury?
Well, based on the way the question is phrased, the answer is probably yes. And if that does happen, then the workers' compensation insurer is now not only liable to pay for your physical injury, but also the mental injury. And this opens up a whole complicated series of aspects of the law. But if you are physically hurt and as a result of your pain, you become depressed, and you have to get treatment for that, antidepressants, see a counselor, something like that, and it is because of that, it is a consequence of that, then the employer-insurer obligated to pay for that mental health care.
Kathy was non-verbally communicating.
Yes, she was. She was rolling her eyes, I believe.
I did not roll my eyes, but we do have a difference of potentially of opinion in terms of whether it's a black and white answer, because it has to. Your key words were consequence of, and
right.
so if it is
you have to prove it.
A medical consequence of an injury, you may be entitled to treatment for depression and for those consequential injuries. However, if you are simply feeling depressed because financially it's more stressful, socially you feel more isolated, that may not rise to the level of a consequential injury. So there are some gray areas with that.
Right. Well, so what Kathy is saying is when you see your doctor, make sure you say, and the pain. And the pain.
And the other issue is this is actually a very common occurrence. A large number of my clients struggle with depression and anxiety.
Isn't it like 70-80% of it really when you think about it after time?
It's not pleasant. We usually tell people if you're in our office, something isn't going right for you. Right. And Kathy and I have had cases, to make what we lawyers will crudely call a psych claim, you have to open the door. And I have very frank conversations with my clients before we make these claims, because if Kathy is the defense lawyer in a claim and I say, my client sustained this emotional injury because of the pain and the limitations, she gets to take that person's deposition and ask them everything. Ask them about their marriage counseling. Ask them about their upbringing, their family, other sources of stress. And a lot of people are just not comfortable talking about that. And
it's not to be mean and pry him personally, but if you put it at issue, there has to be a delving into, is it related to the injury or is it related to potentially pre-existing or prior events in that person's life?
Yeah, it's hard to make a psych claim for various reasons.
We're getting close to being out of time. Stephanie, let me ask you a question that you should be able to answer very, very quickly.
Okay.
Has there been a decrease in the number of workers' compensation claims over the last few years? What's the percentage? What would be the reason for such a decrease?
I thought Bob was in Florida.
Oh, I'm just the reader.
A decrease in claims paid or claimed?
Don't answer a question with the question.
I think in terms of trending, there has been a decline in claims in terms of statistics. And sometimes it can correlate to changes in economy swings.
Right.
There can be demographic swings that affect swings in claim counts and things like that. So I'm not sure if that's what the caller's getting into.
Well, the other thing is workplaces are just simply safer, and people are working smarter. We have safety equipment that we didn't have years ago. People use it. I don't want to say there's no stigma, but there's less of a stigma.
Technology also
for using
has
the safety equipment. Yeah,
has had a factor. There's less manufacturing, less heavy labor jobs in that regard.
Yeah, I almost never get calls from robots. Almost.
Right. Yeah. But and the other as to the percentage of decline, I don't know those things.
Thanks for setting me up, though. That was nice.
And also, in terms of claims made, I think sometimes it's because our system functions pretty healthily. And so in terms of litigated claims made, I'm not sure if they're talking about injuries reported versus claims made. In terms of, I see a claim as potentially a dispute. I think as a whole, our system, the Department of Labor and Industry, really does a good job helping employees go through the system without it being a claim and without it being litigated as well.
And then Dykoff comes along and the claims get denied and we all have work to do.
There's rooms
Yes.
for interpretation.
Right.
All right. Sean, real quick question. We're under a minute here. Can you collect workers' compensation benefits and Social Security benefits at the same time?
Yes, you can. They coordinate, so you don't get a full amount of both. And I'm not going to get into the details of that. But yes, you can.
Kathy, you have seconds. Why am I forced to return to work when my doctor says I'm not ready?
It's a medical opinion versus potentially your own perception and feeling a little anxious about return to work, but typically medically they know what they're doing.
Thank you. Good talk. Thank you for everyone who called and our great panel here. That was good. That's all the time we have. Please join us next week when we answer your questions about accessing legal services. Thank you again to the panelists. Thank you all for watching. I'm Jim Peterson. Good night.
Well, when he said the broken wrist curling, he clearly fired call.
Right.
But I just dismissed the case. My client was donating blood at work as part of a Red Cross thing, and they hurt her in the donation.
Oh,
And
interesting.
her arm is like, she's got the CRPS in the arm. So anyway.
But that's not a
so
work
I-
injury. That's
so
a
I brought-
voluntary.
Right. So I brought a work comp claim saying, look, she's promoting her employer. She works for Delta. She's promoting her employer and all this sort of goodwill. And there's a case on point that says, absolutely not. That doesn't make
For
it work.
blood donation?
For
Or the promoting of goodwill.
any promoting of the goodwill.
Like we're picking up Duluth today, you know,
Yeah.
our company has this team or whatever.
Yeah.
Okay.
If
that-
it's purely voluntary
it's
and the
purely
employer is not encouraging
yeah.
you to do it,
Well,
just
the
because.
employer did encourage her to do it. The employer absolutely encouraged everyone to do it.
To do it voluntarily.
They had these.
Right.
They had
Right.
these, hey, today we're the number 3 company in the United States. So next year, let's be the number 2 company or the number 1 company in blood donation.
What do you mean you're not donating blood? Why
Yeah,
not?
right. And so, but it's doesn't matter.
For your promo, you can.
I almost got up and walked off with my microphone.
Yeah, I almost
That wouldn't have been good.
Well,
You know,
Oh,
I always
I
forget
already
to look at the
unhooked
camera.
mine.
when
I
I
better
talk,
put that
so
back
They
on.
don't want us to.
look everywhere.
They don't want us to. They want us to look at each other and talk to each other.
Oh, they do.
Directly at the camera all the time.
well, let's see how he does.
All 4 cheeks and a couple of chins.
What's shaking there, Mr. Peterson?
Yes.
We'll do one of those side views like
So you know who's on the show next week?
You
You know who's on the show next week? Accessing legal services.
Yeah, I know.
Yeah.
Oh,